The Supreme Court ruled in July 2024 that former presidents are largely immune from criminal prosecution for things they did while in office, as long as those actions are considered official. Let's break it down. The court's conservative majority created a brand new three-tiered system of presidential immunity. Here's the problem. The Constitution says nothing about this framework. The justices just invented it. The same self-proclaimed originalists who struck down Roe v. Wade's framework for not being in the text. Originalism means interpreting the Constitution based on the original meaning. So where in the Constitution does this immunity come from? It doesn't exist. It's not grounded in text, precedent, or the founders' words. In fact, Article 1, Section 3, Clause 7, the Impeachment Judgment Clause, it says that officials removed by impeachment are still liable and subject to indictment and punishment according to law. The founders clearly expected that former presidents could be prosecuted. The justice justified their decision by saying prosecutions might chill executive decision-making. That's not originalism. So here's what the founders actually said. Alexander Hamilton in Federalist No. 69 wrote, "The president would be amendable to personal punishment and disgrace by being prosecuted and punished in the ordinary course of law." This signifies that a president can be removed from office through impeachment and still be subject to criminal prosecution afterward in the standard legal system. This was a key distinction drawn by Alexander Hamilton to argue that the President of the United States would be more accountable under the new Constitution than a monarch who was not subject to the law. Translation: no immunity. The founders had just fought a revolution against a king. They didn't want another one. Until this case, no court in U.S. history had recognized criminal immunity for a former president. Legal experts across the spectrum were blasting this decision. Conservative former Judge J. Michael Luttig said, "This ruling is untethered from the constitutional text and structure." And constitutional theorist Philip Bobbitt added, "It invents doctrine where the framers left none." Why it matters. This ruling gives future presidents a potential playbook for abuse, allowing them to interfere in elections, obstruct justice, or commit crimes while claiming it was all part of their official duties. For instance, the U.S. Supreme Court majority stated Trump's alleged urging of Pence to alter the certification of election results involved official conduct, and Trump was therefore presumptively immune, but that the government could try to rebuke that presumption. I just find the hypocrisy astounding. The justices were suddenly living constitutionalists when it fit their agenda. Bottom line, this isn't just about Donald Trump, it's about whether the president is truly accountable to the law.